Court rise.
Yes, Miss Minot, please.
May it please you, my lords. I don't know if your lordships have to hand the second respondent's written case.
Yes.
But
Yes, I know. Yes, carry on.
thank you, my lords. But just to point out that at paragraph 14 on page 7, just following on from the last point that I made before the break, that the emphasis there that we have given is on lawfulness, whether the direction is lawful or not, as opposed to trying to say that it doesn't have a mandatory effect. And if you turn the page, my lords, while I have you there, could I just change sections 5, 2 references to section 5 should really be to section 4?
Section 4.
Yes, and that's in the 4th to last line and the 2nd to last line of paragraph 14, numbered paragraph 14.
Yeah.
Those 2 references to section 5 to section 4. The second point that I wish to address in the appellant's case, my lords, and the last point that I wish to address in the appellant's case is their submission in paragraph 23 of their case. At the end of paragraph 23, where they say, all functions of the OUR are expressly made subject to the exercise of ministerial power under section 6. Now I ask your lordships to note, to have a look at first of all, the OUR Act and see how section 4, which sets out the functions of the OUR under that act are set out. In contradistinction to how they are set out under the Telecommunications Act. Now, under the OUR Act, you see paragraph 4 starts subject to the provisions of this act, and then it goes on the functions of the office shall be, etc., etc. Now, section 4 of the Telecommunications Act, which sets out the functions of the office under the Telecommunications Act, by contrast, just states, the office shall regulate telecommunications in accordance with this act, and for that purpose the office shall. So that when I look at section 4 under the Telecommunications Act, I am unable to find where it is expressly stated that the functions of the OUR under section 4 are subject to the exercise of ministerial power under section 6, as my friends have submitted. In fact, the words subject to are in fact used in the Telecommunications Act expressly, and you will see them, for instance, in sections 7.2.
Sorry, section 7.2.
Yes, just to show you examples of where the words appear, subject to. 7.2, 7.3c, 13.3d, 14.6, etc., but not in section 4.
But how is section 4 to be read with section 6 then on that basis?
Well, I think Section 6 stands on its own, and in providing that the functions shall be, the office shall give effect to those directions. There is a requirement that the office perform its functions in accordance with the directions of a general nature which the minister has given. But the Act, as I said, and this is where I think I'm pinning my flag to the mast, does not contemplate a situation where the direction given by the minister would be unlawful.
I'm lost. You're talking about Section 4 of the 2000 Act. I mean, Section 4 of the OUR Act, the 1995 Act, are you saying somehow that that is exempt from any direction under Section 6 of the other Act, or what? I'm lost. I'm sorry. It's my fault.
No, the simple point I was making, my lord, is that my friends have said that it is expressly that Section 4, the powers, the functions of the OUR under Section 4 of the Telecommunications Act.
The 2000 Act.
Yes, that those powers, those functions are made expressly subject to the exercise of a ministerial power under Section 6 of that Act.
Well,
But then I would have expected to see the words in Section 4, subject to Section 6, the functions of the OUR are. That's a simple point that I'm making.
I see.
As I see in the OUR Act, where it sets out the functions of the OUR, it says subject to the provisions of the OUR Act.
I see.
So it's the simple point I'm making is that
Yes,
it is
yes.
not expressly so
I'm sorry,
stated.
it is simple, and I have failed to gather it.
So the short question in relation to issue 1, really, my lords, is does the power given to the minister under Section 6 of the Telecommunications Act include a power to prohibit the OUR from intervening in the market to set tariffs, rates, and price caps? And that is where we come to the cases of Municipal and Virgo and TAR and NG Enterprises, etc. And as your lordships have indicated earlier in that regard, in each case it's a matter of construction of the statute. And it is our submission that on a proper construction of the statute, the answer to that question is no. If the OUR must be free to set tariffs, rates, and price caps as and when necessary to promote the interests of the public and customers and consumers, then that ministerial power does not allow prohibition of that activity. And that, my lords, on this, I can be of any. So just to make the final point, if I may, that the questions in paragraph 14 of the appellant's written submissions the 3 questions set out there in our submission would all be answered no. So unless I can be of any further assistance.
Could I just ask, I mean, these determination notices and so on, which we were looking at earlier on, do they get published in the Gazette, or are they public documents, or how does it work? The determinations
Termination notices were published by the OUR, my lords.
Goes on the website.
Were they published in the Gazette? The termination notices?
No.
I'm informed that they were not.
They're not published in the
I am
Gazette.
informed that they were not. And Mr. Garcia, my lord.
Thank you very much. Yes, Mr. Garcia.
Please you, my lords. I did spend some time concerned with an issue which I think has been of some concern to your lordships as well, which is that of time. And with that in mind, I prepared a speaking note, which I am hoping will assist me in presenting in as short a time as possible today. My Lords, before going into the two issues which I need to address, which are agreed issue number 3 and what we've been referring to as issue number 5, the issue raised by the second respondent, I thought it would be useful to look again at the statutory context. I don't propose to go back through the statute in detail as my friends have done before, but I am concerned to look again at the provisions of section 32 of the statute, because that is the section under which the OUR purported to act in issuing its determination of May 22. And just before I go to that section, which deals with reference interconnection offers and the approval of them, there is, of course, section 27, which commences the part dealing with interconnection, and it defines a reference interconnection offer as meaning an offer document setting out matters relating to the price and terms and conditions under which a public voice carrier will permit interconnection to its public voice network. And I think it's fairly significant that price is there, indicated in the definition of what would be included in a reference interconnection offer. Section 32 of the Act, then, my Lords, requires every dominant carrier to submit a reference interconnection offer, and it indicates in subsection 1 that any other carrier may submit one. And then in subsection 2, of course, there is a reference to the incumbent Cable and Wireless submitting its initial reference interconnection offer within 30 days. So after the submission of that interconnection, of that first reference interconnection offer, that first RIO by Cable and Wireless, it was contemplated that Cable and Wireless may submit others. And I think it actually is a little bit more than contemplated that it may, but in fact that it would, because the Act would have come into force with Phase 1, under which certain licenses were issued. Under Phase 2, the domestic licenses for fixed services would have been issued to other competitors, and then under Phase 3, other international licenses would have been issued. And so it would have been necessary, at least under Phase 2, and also, yes, under Phase 3, for there to be new terms for interconnection between the carriers. And so it was, I think, always anticipated that Cable and Wireless would have submitted a RIO at the commencement of the legislation, and then again, at least, at the commencement of Phase 2, 18 months after the commencement of the legislation, and then again also at the commencement of Phase 3. Now, all of that, of course, would not have been necessary to put that in the legislation in circumstances where the Act says that they may submit a reference interconnection offer. Subsection 4 then says that the RIO or any part thereof shall take effect upon approval by the office in the prescribed manner. And it would seem to me, therefore, that if a carrier did decide to submit a reference interconnection offer, then pursuant to subsection 4, the Office of Utilities Regulation would have to consider that reference interconnection offer and, if thought fit, approve it. And again, it is to be borne in mind that that RIO would have included terms and conditions in relation to price. Before I leave this legislation, my lords, there was some discussion in relation also to section 34 of the Act. The marginal note indicates that it deals with pre-contract disputes, and so does subsection 2 of that provision. It doesn't seem to me that section 34 would arise for for specific consideration in the context of this case, because we were here not dealing with a pre-contract dispute, but with the submission by Cable and Wireless of a reference interconnection offer for consideration by the office, and that would therefore have been submitted pursuant to Section 32, and the relevant power that the office would have been exercising would have been that under Section 32, subsection 4 of the legislation.
The contract itself made express provision for reference under Section 34.
I did actually, my lord, think that was a fairly curious reference. It refers to both Sections 29 and Section 34. The reference to 34 I thought to be fairly curious because it's referring to pre-contract disputes in an agreement which of course has already been concluded, and consequently in that context there would be no pre-contract dispute.
Unless you treat Rio 4 or potential Rio 4 as the contract.
Indeed, but in that case, my lord, it would again, I think, be curious to refer to Section 34 rather than Section 32, because Section 32 is the provision under which the Rio gets approved. But I don't think much can turn on that, because the point is that it is the statute which determines the power given, certainly the statutory power that was given to the Office of Utilities Regulation to
Am I right in thinking
approve
that
the
in
Rio.
each of these cases it was Cable and Wireless who were submitting the Rio?
Yes, my lord, that is
There's no case in which any of the mobile carriers was...
No, my lord. These were all concerned with Rios submitted by Cable and Wireless. If I may then turn, my lords, to page 2 of the speaking note, the bottom of the page, paragraph 3, I then seek to set out some of the contractual context. Subparagraph A, I note there that Cable and Wireless had submitted its first Rio in 2000. The reference is incorrect. That was the reference to the proposed terms of interconnection, which accompanied the minister's request for proposals. The Rio, as my friends had earlier indicated, is not in fact in the record. And what then happened after that first Rio was submitted is that after a process of consultation and indeed revision of the Rio, the OUR approved Cable and Wireless's Rio in its February 2001 determination notice. And I would like to make I don't think there has been very much reference to this previously, and I would like to refer to a few provisions in that document. It's in volume 1, tab 8, page 265.1. And at page 265.2, my lords, the abstract common to these determinations of the OUR indicated that what was expected is that Cable and Wireless would revise its Rio consistent with the determination notice, and so it would submit a new one, and then that one would essentially be the one that is approved. Chapter 2 of the determination notice is, I think, of some significance, page 271.
Now this is all history, isn't it?
Yes, my lord.
Quite old
I think it will be of some significance in terms of, well, both issues 2 and 3 of particular importance to me would be issue 3. And and the relevant portion of the history insofar as chapter 2 is concerned is that this chapter indicates that it was always intended that the duration of the initial charges set under this RIO would be short, and that further RIOs were to be submitted by Cable and Wireless. The determination also makes some reference to the calling party pays regime at pages 280 to 281. And what I think is significant there is that the calling party pays was not a regulatory requirement. It wasn't imposed by the Act or by any regulations under it. It was something that the OUR describes here as something that entrants may want. And the OUR had decided that it was a service which the office thought should be provided for mobile carriers. And so when one comes to look at the question of capping the mobile termination charge, there certainly was nothing that would have prevented a mobile carrier, if it wished, from collecting part of the its mobile termination charge from the originator and part from its customer. There was no regulatory requirement to stop it from doing that. But certainly the expectation was that the charges would be calculated in such a manner that Cable and Wireless would have been required to pay a sufficient sum to cover both its retention and the costs of termination as well. The determination also went on to deal with the termination charges, the charges relating to incoming international calls and fixed to mobile calls. I don't think it's necessary to refer to it at this point because by the time because this is what, of course, then was reflected in the tariff schedule, to which reference has already been made. And then by the time we reached May 2002, there had already been another interim determination on both of those charges. And so the charges that are set out in this document had changed before we reached to May 2002. And I will take your lordships to that in a few minutes. The interconnection agreement, my lords, some reference was also made to that earlier, in particular to clause 23 of that document, and that document is in volume 2, tab 10. I wanted to refer to it also because I don't believe previous reference was made in the course of oral arguments to clause 10, which I think is also of some relevance in this matter. And clause 10 is the one that specifically deals with the variation of charges. And it's at page 695 of tab 10, volume 2.
This is what's actually called long form.
This is the long form interconnection agreement, my lord. It's the agreement which commences on page 690.
Page what?
The agreement commences, my lord, on page 690, and the relevant clause 10, is at page 695.
The other thing, which is the full interconnection agreement, its main function was to transfer from the interim agreement, and is that right? I mean,
So it would appear, my lord, and I suppose a curious feature is that they're both dated the same day.
Yeah. They are. But I think the other one is largely to do with bringing a transitional thing from what had been an interim agreement of some sort, and that seems to be the main.
Yes, my lord, and that certainly is dealt with in clause 3 of the short form.
Anyway, it doesn't matter.
So in clause 10, my lord, and this is certainly in addition to the review provisions that exist in clause 23, specifically in relation to charges. Cable and Wireless could, under clause 10.4, from time to time notify telco, which is defined in this agreement as Digicel, of changes to charges being 1, charges approved by the OUR, or 2, charges changed as a result of changes made by third-party telecoms providers to their charges. And so under 10.41, it was contemplated that the OUR could approve charges, which could then be notified by Cable and Wireless to Digicel pursuant to this agreement, and those new approved charges would then become effectively a part of the tariff schedule to this agreement. So there would have been both the power under clause 23 and the power under clause 10. Significantly also...
Which was it here? I mean, was it...
I'm sorry, ma'am.
Which one was it? Was it a 10.4? I mean, because what we were looking at is certainly something which is done, the determination of the 22nd of May or whatever it is certainly done in the context of contemplating Rio 4. But...
My Lord, it would seem to me to be both. And it is for the reason that Rio 4 would have dealt not only with charges, but with other changes to the interconnection agreement. 10.4 would have allowed a determination only in respect of charges. And then clause 23 would have allowed a wider determination. And so in 23.1, it says, without prejudice to the provisions of clause 10, either party may seek to amend. And so it seems to be providing a wider power. Also in relation to clause 23, I think it's significant to note under 23.1c the indication that for the avoidance of doubt, and this is the point I think I was making earlier, revised RIOs will be submitted for approval at the commencement of phase 2 and the commencement of phase 3.
And would they supersede the F3?
To the extent that there are differences in the terms approved, yes, my Lord. That would be my understanding. And consistent with that, Cable and Wireless, and I should say phase 2 would have commenced in September 2001, and consistent with that, Cable and Wireless submitted its Rio 4 on August 28, 2001. So that's just before phase 2 was to commence. And that's, of course, at the expected time. The reference to that, my Lord, is volume 2. It's in the same volume at tab 9, page 584.
Yeah.
And it's not the Rio 4, it's the... Oh, I'm sorry, I think...
It is. Paragraph 1.0 refers to them submitting a revised Rio 4.
Yes, ma'am.
I've
spent it, I have, my Lord. The earlier, my Lords, I had referred to the interim determination, which I think represents the last position in relation to rates before the Minister's direction and the OUR's determination of May 2002 were issued. And that interim determination was in November of 2001. It's at, I've referred to it at subparagraph F on page 4 of the speaking note. And in the record, the material is at, the determination is in volume 2, tab 10. And the document actually begins at page 769. The references in my note are to the provisions in relation to fixed to mobile termination charges and international to mobile termination charges. And they are conveniently summarized in 2.0 on page 773. Subparagraph 3, maximum retail rates for outgoing for calls originating on CNW fixed network to any mobile network, including CNW, shall increase by 8.7%.
And do I understand from 2.1 that they came into force on November the 22nd?
Yes, my lord.
And that's an effective variation, at any rate pro tem, is it, of Rio 3?
That I believe is correct, my lord. And so this would have been the interim determination that then preceded the May determination.
And
in relation to 2
did this result in a variation of the contract,
Yes, my lord.
just automatically treated as such?
Well, I think that notice would have to have been given pursuant to the determination.
We don't have that in the
That's what
bundle.
the contract said, but we don't have that in
No,
the
I
bundle,
see.
my lord.
I mean, it's all a sort of ongoing process, isn't it? Because, I mean, even the one which we call the main determination, the abstract makes clear that there was a whole bit of it which they had parked and which there was going to be dealt with later because they hadn't yet analysed the submissions on the point or something like that. And they only dealt with domestic and incoming or whatever it was.
Yes, my lord. It did seem to be an ongoing position. And what would also be happening is that during the course of, is that Cable and Wireless would be submitting revised RIOs as we go along. And in some cases, the office may be making a determination, I think, even without the submission of a RIO. In this case, there is actually no indication in the abstract that what the office was here doing was to make a determination on a RIO. Instead, what it indicates is that it's become necessary to make some revisions to RIO 3. And RIO 3 had, of course, by this point already been approved and was already in effect.
What was the past history before the 2000 Act came into force? You had Cable and Wireless there as a monopoly.
Yes, my lord.
And presumably there was an interrelationship between the office and Cable and Wireless then.
Yes, my lord.
And I get the impression that that history rather dictated the way they went on treating each other. The Cable and Wireless accepted it as almost axiomatic that the office had to approve their charges and so on.
At that stage, the office would have been concerned substantially with retail charges.
Yes.
And that's the power that would have been exercised under the Office of Utilities Regulation Act. The Telecommunications Act introduced a very new variable, which was new entrants, with the consequence that the office now had to address not only the question of Cable and Wireless retail charges, but also interconnection with the new entrants.
I entirely follow that, but this history that you're showing us seems to me indicative of an existing relationship under which Cable and Wireless assumed that they had to get everything cleared with the office if they were making changes to their pricing structure, whether or not they were having the full formality of a new RIO.
Well, I would think, I would suggest, my lord, that Cable and Wireless would have been proceeding at this point on the basis that the Telecommunications Act required it to submit RIOs before its charges could be approved. And so that's the context in which Cable and Wireless would have been making these submissions.
I mean, the last determination notice we have before the key dates is it in February?
That is so, my lord. I believe it's February 7, 2002. And I actually make reference to that overleaf. And if I may, there's one other document to which I wanted to make reference before I got to that, which is a consultative document in December 2001 in respect of RIO 4. And that consultative document, unfortunately, is not all in one volume. It's spread over two volumes. The first few pages of it are in volume 1, and the rest of it is in volume 2.
You summarise the key bits in your note.
But I do summarize the key bits, my lord, and I think I will just go there. First of all, the document reflected, and this is the OUR's consultative document, reflected a concern that mobile termination charges for international to mobile calls should cover the cost of mobile carriers so that the mobile carriers would not be subsidizing cable and wireless fixed network. And that became a central theme, and I think my friend Mr. Batts referred to it earlier in terms of the rationale that the OUR had for issuing its determination 2.8 in respect of incoming international calls. The determination also noted Digicel's failure to submit a cost analysis of mobile termination, and this was a point that the Court of Appeal found to be of some interest at page 35 of its judgment, and which I have also explored in a little bit more detail, I think, than the Court of Appeal in paragraph 80 of Cable and Wireless written case. And what had happened there, my lords, is that the evidence indicated that as far back as the year 2000, the OUR had been asking Digicel for costing information in relation to mobile termination, or orally apparently in meetings, and then certainly in writing by November 19, 2001, there was a request for the information. Digicel made a number of different complaints in relation to the request. One was that they asked the OUR, why do you need it? Another was that they said that the time that had been provided within which the information was to be supplied was too short. Apparently the OUR's request had been to provide it within 2 weeks, and Digicel's response was, well, that's not enough time. And that request would have expired as at the end, I believe, of November. What I think is then of some significance is that in December 2001, in the consultation, the OUR criticized Digicel for not having provided the information, and Digicel took issue with that criticism. Meanwhile, by March 2002, Cable and Wireless provided its information in relation to termination on the mobile network, and by the time May 2002 had come, which was of course some 6 months after the written request for the costing information, it had not been provided.
And we see the timetable, don't we, at page 90.1 of tab of the bundle 1, which is of some interest because it shows that the timetable contemplated at that time was that there would be a response to the constitutive document by April the 12th, and that there would then be comments, and then there would be a determination notice on May the 3rd,
yes,
which of course was after what you might call the critical moments.
Indeed, and the information had been requested long before the March 15th.
Now, what is the evidence that the minister was aware of all this? Or is it obvious that the minister was aware of all this?
I don't think there is evidence that the minister was necessarily aware of the communications in respect of the costing information.
No, but he was presumably aware that the negotiations for Rio 4 or something like it were
He certainly would have been
ongoing,
aware of that.
the whole question of price would be central to those communications.
Indeed, my lord, and it would seem to me that if he were not aware, intending to issue a direction such as that under Section 6, he would reasonably have wanted to make himself aware of what was happening and of the context in which that direction was then to be issued.
Mr. Hayes' affidavit, paragraph 33, volume 2, page 2608, deals with the late March position and the discussions between Hay and the minister. And Hay says he explained we had a commitment to revisit FGM prices and already begun the process of consultation with the stakeholders, etc., etc., etc.
I'm sorry, the paragraph, my lord?
33, page 608. I mean, but I mean, it's
Oh, yes,
not
I know.
altogether surprising. I mean, you know, the whole point of the directive was to stop it, I suppose.
My Lord, it seems to me that certainly is not how the minister articulated it, and I don't think there's been a finding yet that that's what the minister intended to do, but I could
Why
certainly
not? I mean,
understand
I thought the whole point
if
of it-
one saw the evidence that way.
Well, it was Mr. Hayes' case at the minute, that's what the minister intended.
That is what
But there's
Mr.
no
Hayes said that
finding,
the minister
no
was trying
finding
to do.
on the part of the Court of Appeal that that was what he was up to, and no challenge to that area of the case.
And the minister, but the minister also did not. The minister did not say that that was his purpose. And of course, none of the parties were cross-examined. I then come, my lords, to the determination issued on February 7,
Yes.
2002, which I think was the last determination in respect of, this determination was in fact in respect of Rio 4, but not in respect of all the issues in Rio 4. And so what the OUR did was to indicate that Cable and Wireless did not need to submit a revised Rio in relation to the February 7, 2002 determination, but they could instead submit their Rio after the pricing issues were determined. And it is, of course, the pricing issues that were to be the subject of the May 2002 determination. And so, my lords, the minister's direction of April 2002 and the OUR's determination of May 2002 were therefore issued in a context where, at paragraph 4 of the speaking note, the legislation contemplated that a Rio could be submitted by Cable and Wireless and could only take effect upon the OUR's approval. Now, I realize that it says the OUR's approval in the prescribed manner, and there were some comments in relation to the prescribed manner day before yesterday. The Section 32.4 does say in the prescribed manner. Section 32.3 also says that the terms of the Rio are to be in the manner prescribed. And so it would seem to me that if the failure to prescribe were to mean that the sections were entirely inoperative, then the Telecommunications Act would have been deprived, I think, entirely of its structure until either the manner was prescribed or the Act was amended. But I don't think there's a significant point to be made in relation to that. Subparagraph 2 of paragraph 4 of my speaking note, Cable and Wireless, the context in which the determination and direction were issued, Cable and Wireless had submitted a Rio which included rates and charges to be changed from those under the existing interconnection agreement, and with the mechanism for changing them involving the OUR and being provided by the interconnection agreement. The written submissions to the OUR, thirdly, in respect of Rio 4, show that the terms of interconnection were very much in dispute between Digicel and Cable and Wireless, and there are a number of documents which are exhibited to the first affidavit of Mr. Seamus Lynch in Volume 1, Tab 8, which show Digicel's disagreement with the terms that Cable and Wireless was seeking to be incorporated into the Rio. And
In fairly forthright terms.
Indeed, my lord. concluding, of course, with the suggestion at page 198, I believe it is. Wait, no, that's not where it is. Concluding with the suggestion that the OUR may be the subject of some improper influence.
Yes.
That complaint has not, of course, been been pursued to this level. And so, my lords, if it is correct that the OUR could indeed make a determination where there was a dispute between the parties, I think that the evidence indicated, certainly in that volume, shows that there was very much a dispute between the parties as to what was to happen to the rates in the context of Cable and Wireless seeking to have them changed under pursuant to the interconnection agreement and by the submission of a new RIO. And the office, of course, in approving the RIO or in resolving the dispute, is not actually intervening by setting rates and charges, but is instead responding to a RIO that has been submitted to it, and which, of course, by virtue of the Act, it had an obligation to consider and, if thought fit, approve. And so I asked the question, if the direction indeed was to stop the OUR from setting rates and charges, which I don't think it was, the question may be asked, how was the OUR to approve the RIO that had been submitted in accordance with Section 32 of the Act and in accordance with the interconnection agreement? And worse, my lord, in the context of all of this, is that the OUR was in the process of conducting a public consultation. The consultative documents were being published on its website, as it typically does. The determination, the February 2002 determination had been published and indicated that another determination was coming in relation to prices, such prices having been requested in the RIO 4. And in that context, the minister issues a direction not to intervene in the market by setting rates, price caps, tariffs, charges. And then when asked about the direction by the OUR and asked about the publicity that should be given to the direction, the minister's response is that it should be kept confidential. And so, the public consultation is taking place in relation to rates and charges. The OUR is not to approve the rates and charges and is not to tell anyone why. Paragraph 5. Added to all of this is the fact that it appeared that international settlement rates appeared likely to trend downwards. And my friend Mr. Batts, I think, also referred to this aspect of the evidence in looking at the rationale given in the May 2002 determination for determination 2.8. And the trending downward of international settlement rates was something over which Cable and Wireless would have little, if any, control, because, of course, it would have reflected some pressure from larger players overseas, and who, as Mr. Batts indicated earlier today, would have been, in the case of the United States, coming under some pressure from their regulators there. And that presumably is why, in the very determination, the OUR, while expressing its desire that Cable and Wireless would negotiate higher settlement rates, also indicated that it would lend its full support to Cable and Wireless Jamaica to avoid the unfortunate outcome of international settlement rates falling to such a level that they could not cover both the mobile termination and Cable and Wireless's cost for transiting the call. And so the scenario, my lords, and in fact what then did in fact happen is that international settlement rates fairly shortly after the determination did in fact fall to such a level that they would not have been able to cover that cost. And the significance there, my lords, is that when the international settlement rates fall to that extent, it means that Cable and Wireless costs of transiting the call can't be covered, And so they would have no interest in transiting the call if they can't cover their costs, and the mobile carrier's costs can't be covered. A part of the context for that situation, however, is of course that the Office of Utilities Regulation has been forced to estimate what that mobile carrier's costs were, because the carrier had decided that it did not wish to provide its costing information. And if I may pause there to mention one other interesting feature, it is that the part of the irrationality charge that was brought against the OUR in this case was that it failed to take into account Digicel's costing information. So I thought that was a fairly interesting basis on which to challenge the determination.
I mean, all you're really telling us is it was a rotten policy that the Minister was directing OUR to follow.
Yes, madam.
Why are we interested in how good a policy it was? All we want to know is whether or not they're entitled to direct it, surely. Well, and then you come at page 6 to issue 3, which is, of course, a quite separate question as to whether you actually breached the direction in the first place.
Yes, my lord. But I think this issue does, of course, reflect on the rationality. So in relation to issue 3, my lords, paragraph 6 of the submissions, I noted, my lords, that Mr. Batts was asked to give his view on this issue, which was that the OUR intended to breach the direction, although perhaps it didn't amount to a technical breach. I submit that this is an issue which nevertheless requires serious consideration, regardless of what the intentions of the OUR were, because the fact of the breach, it's the fact of the breach and not the intention that determines whether or not, of course, the determination can stand if it is that the direction also stands. And this is particularly so in circumstances where there are parties affected, such as Cable and Wireless Jamaica Limited, who was not a party to the intention either of the OUR or of the Minister. With respect to the arguments on it, my lord, the learned, or the findings on it rather, the learned review judge did not address the issue, even though we believe it did arise for determination based on his decision.
This point arises if does this point only arise if the direction is valid?
It arises only if the direction is valid. Yes. And so it arises only if your lordships are in agreement with the appellant on issues 1 and 2 and on the interpretation.
1 or 2?
Well, my lord, I think that's an issue in itself. As I understand the arguments in relation to 1 and 2, it is that if it is unlawful, it must also be that it is retrospectively, once held unlawful, it did not need to be obeyed at the time that the OUR did not obey it. So I think 1 and 2 go together, my lord. The Court of Appeal dealt with this agreed issue number 3, and it's the reasons that it gave. I'm not going to seek to spend too much time on the reasons that it gave, because the reasons that on which my lord, the then president of the Court of Appeal, Mr. Justice Harrison, relied, had primarily referred to the retail rates of Cable and Wireless Jamaica Limited. And the difficulty with that is that when one looks at determinations 2.6 and 2.8, those determinations are both directed towards the termination rates. Now, of course, part of the context for determination 2.6 was 2.5, and 2.5 was concerned with the retail rate, but 2.5 was not challenged in the judicial review proceedings. And so in those circumstances, the arguments that I will address are in relation to 2.6 and 2.8 and the termination rate. Digicel addresses this issue at pages 20 to 28 of its case, and the main argument seems to lie in a criticism of the Court of Appeal for focusing on whose customer was to be charged. And that's in respect of paragraph 1 of the direction. In respect of a breach of paragraph 2 of the direction, which was the one in general terms, the Digicel's argument is that the effect of determinations 2.6 and 2.8 was to inhibit competition and investment for the mobile carriers. And the short answer in relation to paragraph 2 is that argument is not established on the evidence. In relation to paragraph 1, the arguments of Cable and Wireless are set out in paragraphs 43 to 45 of our written case, and I've summarized the main points in this speaking note, my lords. And first is the argument to which I made reference earlier, that Digicel's mobile termination charge was not in fact capped by the determination. What was capped was the amount that Cable and Wireless was obliged to pay to Digicel. And consequently, Digicel would have been in a position, if it so wished, to charge its customers any further amount that it may wish to collect in respect of mobile termination. And another option that was available, perhaps theoretically, is that Digicel could charge higher rates than the amounts approved by the OUR to Cable and Wireless. Because the OUR's determination was not saying that Cable and Wireless could not pay more. It was saying that Cable and Wireless was not obliged to pay more than the amount that was set out in the determination. And so Digicel would have been free to say, well, this is the amount we'd like to receive for mobile termination. We would like, for instance, to receive $10, and even though it may not be, even though your retail charge, or in the case of international, the settlement rate may not be sufficient to cover it, we'd still like you to agree to it. It would be market forces that would lead Cable and Wireless to say, oh,
if
no,
they
we
didn't,
can't
would
agree
that be
to
a matter
rate.
to be arbitrated but by the OUR?
It perhaps might be, because in those circumstances, I think the difficulty that we would have is that interconnection would entirely break down. Because what the OUR was saying, I think fairly explicitly in paragraph 1.6 of its determination notice, and then in determination 1.1, is that this is the extent of the obligation that we will place on Cable and Wireless in terms of interconnecting. So if Digicel chose to demand more of Cable and Wireless then had the option, which it would not otherwise have had, of opting out, of saying, as would any commercial party, well, I don't like the terms of this agreement, and so I'm not going to agree to it.
I'm sorry, it's my fault entirely, but if we just look at the determination 2.6 and you look at the direction, I mean, how do you just take it? Just if you could just explain, give me an example. Just explain how exactly you say it fits and why it doesn't breach.
My lord, the determination 2.6 and 2.8 both have to be read in the context, my lords, of paragraph 1.6 and determination 1.1. So if I may start there, those are at page 585, tab 9, volume 1.
Yes.
And it starts off, the office does not regulate the rates that Cable and Wireless Jamaica Mobile or any other mobile carrier charges its own customers. In particular, any mobile carrier...
I'm sorry to interrupt. Can you just give us the reference again? I've got a bit-
585, volume 1.
585.
Oh, I'm sorry, volume 2.
Volume 2,
I'm sorry,
585.
I'm so sorry.
2,
It's
585.
volume 2, tab 9.
Okay, thank you.
Thank
you.
Page 585. In particular, any mobile carrier, and I'm reading from paragraph 1.6, can impose airtime charges on its own customers for terminating calls in addition to the amount it receives in termination charges. And then determination 1.1, CNW Mobile is required to participate in the FTM calling regime and may set non-predatory price, etc. And I think the most significant is the last sentence. Other mobile carriers, that is other than cable and wireless, may set a higher rate than the maximum allowed for CNW Mobile, but CNW Fixed cannot charge a higher retail rate to its customers than the maximum determined by the office, and, this is a significant part, shall not be required to pay any mobile carrier more than the maximum rate that applies to CNW Mobile. And so therein lies the cap obligation on the part of cable and wireless.
Well, why isn't that a cap, even if it's open to
My Lord,
mobile?
but it's not a cap on the charge, it's a cap on the obligation of cable and wireless. And so in that context, it says, shall not be required to pay any mobile carrier more. And so it's not, shall not be entitled to. The language, I would think, is deliberate. What the OUR here is doing is saying that we're not concerned here with what the mobile carrier charges. What we're concerned with is what is cable and wireless obliged to pay. And cable and wireless is obliged to pay only the amounts that are approved in this document. And the option indicated in particular at paragraph 1.6, I think, helps to explain it, which is that cable and wireless is only obliged to pay this amount, and if it is that the mobile carrier wants more, one option is already explained in paragraph 1.6, is that it can impose airtime charges on its own customers for terminating calls.
1.6. Oh, is it 1.6?
Paragraph
Yeah, I see.
1.6. The paragraphs containing the analysis have a separate numbering arrangement from the paragraphs with the determinations.
You say that when they say you're not required to pay any mobile carrier more than the maximum rate, does that mean that that's not a cap on the amount which the mobile carrier can recover? And that's not a price? Or
It's a cap on the amount that the mobile carrier can require cable and wireless to pay.
And that's
It's not a cap.
It would not
a
have
price,
stopped. It would not have stopped the parties as commercial parties under to agree between them that, notwithstanding the amount that the determination says must be paid, the parties could agree to a higher sum.
You say it's
And
not a cap
what I'm saying is that commercially they wouldn't have done so.
It's not a
But-
cap, though, because cable and wireless could, at any rate in theory, lawfully have agreed to pay more.
pay more?
Indeed, that's the argument.
That's the argument, yes.
And
However, it's a practical cap, isn't it? Because everybody knows cable and wireless would never agree to any such thing, except
well, my lord, the
except
minister
being
wanted
dragged,
market
kicking and
forces to
struggling.
operate, and they would have done so.
I'd even be said to be a tariff, I don't know.
And so I think, and so I make that very point, my lords, in paragraph 11b. In other words, the determination would not have prevented market forces to truly determine the matter. And to use another example, my lords, I use here the example of a wholesaler and a retailer. And in the case of international to mobile, I think it's a useful comparison, because what is there happening is only so much money is coming in from international settlement, and the context here is the Cable and Wireless has to keep so much to cover its own costs and then has to pay over an additional sum to Digicel. And if what the minister is saying is that Digicel can simply come to Cable and Wireless and say, well, I'll tell you how much I want, and whatever it is, it has to be paid, regardless of whether it's more or less than the sum that that Cable and Wireless is taking in. It's as though one were to say to a wholesaler, well, when a retailer comes in to purchase goods from you, you have to sell it to him, and you have to sell it to him at whatever price he sets, regardless of whether it covers your costs. That perhaps goes more to the rationality argument than it does to this issue number 3. Further, my lords, section 32(4) of the Act effectively requires the OUR to approve a RIO submitted by a carrier. The RIO, you will recall, takes effect only upon approval by the OUR. Thus, the rates payable by Cable and Wireless for mobile termination represent offers by Cable and Wireless, approved by the OUR, not rates set by the OUR, not an intervention. It is Cable and Wireless's rate, which the OUR said, in response to which the OUR says, yes, I approve. They also represent rates capped as agreed by the parties and reflected in the interconnection agreement, not charges that are simply made by Digicel as a mobile competitor, because there was always a cap in the interconnection agreement on how much would have been paid for mobile termination, and that cap, as we had previously illustrated, had been previously approved by the OUR. So what we were seeking here was a change in the amount. And so those, my lords, are my submissions in respect of issue number 3. First, that Digicel could charge its own customers the difference. Second, that Digicel could charge higher rates to Cable and Wireless if Cable and Wireless would be so good as to agree to pay them. And third, that having regard to the approval process, it was an approval of rates offered by Cable and Wireless, not a setting of rates by the regulator. And then I turn, my lords, on page 10 to the arguments in relation to the Interpretation Act. And this, of course, is the issue that was not raised in either court.
I thought we'd already heard this party's argument on this issue.
Sorry, my lords. This was the issue that was not raised in the courts below.
I wouldn't entertain this now if there was anything.
Too late. I agree, too late.
Too late. I mean, if there was anything, we wouldn't have it. No, we don't wish to hear you on this. The position is that if this was a good argument, it's too late to raise it.
Well, I thank you very much, my lord. I don't think it matters that I don't agree. May I just indicate, my lord, my Learned Queen's Counsel had indicated when commencing his submissions that the rules provided, one of the provisions of the rules in relation to the entertaining of a new argument, and your practice direction on hearings actually does quite clearly indicate that it is a permission that a party would have to seek. And I know that was something that was troubling your lordship.
We would need a lot of persuading that we had, by new practice direction, allowed parties to raise any point, however late.
It's in the practice direction.
The practice direction doesn't set out the basis for the permission, so your lordships are at large. Much obliged, my lord. Thank you.
I was rather looking forward to dealing with the...
Sorry, rob you of that pleasure.
Taken away that these things happen. Well, could I, again, be as brief as I can on the issues? I'm slightly troubled when I come to issue 3, the one that we've been hearing submissions from, that your lordships have now had an extensive speaking note dealing with a lot of documents. I hope I can cut through all of that, and if not, my lord, then perhaps you'll tell me if I'm trespassing on the time.
As far as the time is concerned, Mr. Fleming, we can run on a bit if you need it.
But my lord, I'm hopeful to make a 4 o'clock cut-off with ease. Lord, could I just come back with one or two, no, I'm fine, preliminary thoughts, and that is, the reason that I was keen when addressing you in opening, my lords, was to put section 6 into its proper context. That was the purpose of looking at the surrounding sections in order to identify and then examine the functions, powers and duties that could have been subject to the exercise of ministerial power under section 6.
Sorry, may I be allowed to make an inquiry of the court?
Yes.
I'm sorry to interrupt, learned Queen's Counsel, my lord, but I make so bold as to say that, as my understanding is, the council has a right of reply to new authorities cited. And we cited no new authority, nor did we, for our part, introduce any new element to the case. So, if there's a practice here, my lord, it's a practice here, but I write to inquire whether it's a practice to allow a further submission.
It's you who'd have a right of reply if he now in reply cites fresh authority.
We always grant a right of reply.
Yes.
It's a right of response that sometimes is claimed after the
I just rose to inquire, man.
Lord, in anticipation, there is one authority I want to show you, lordships, but that's really out of an invitation on day 1 to show you the coal board case dealing with the difference between general and specific. So when I get there, the reason for the earlier submissions dealing with where are the prescribed rules was of some importance, not merely to question the validity of decisions made by the OUR, because that's no longer part of our challenge. That was issue 4. But to look at the context in which, the regulatory context in which the ministerial direction was made. And I was particularly keen to point out, and it took quite a long time to get there, that section 46 doesn't have any rules as to when there will be an intervention to set price caps. And section 29(3) doesn't have any rules in the sense of those that are approved by the parliamentary process as anticipated by section 71. And what one has in this case in relation to this regulator is a most extraordinary situation. This isn't a case of not complying with its own rules, not setting a date or missing a particular paragraph. This is a regulator who has no rules, no prescribed rules, into many of its key areas, particularly section 29(3, relevant to these submissions, and 46. So I was concerned to raise with the court an understanding of that regime and why it was rational, which was part of the challenge to the minister's decision, to exercise his ministerial power to give a rather clear steer as to where this regulator should be going in terms of intervening in the young mobile market in Jamaica. It's particularly useful to focus on those two sections, 29 and 46, because they were the sections which were touched on in the Court of Appeal as being areas where the effect of the ministerial direction was to prevent the regulator from discharging its statutory function. Well, could I spend a little time for a moment with section 29, because we've now heard a series of submissions on section 29, and I'm anxious to ensure that if and when your lordships deal with the statutory framework, either you don't reach a final view on section 29(4), or you reach the, if I might say so, the correct view on 29.4. Because for this reason, there is, as you can see from the written speaking note from my learned friends representing Cable and Wireless, that they're anxious to point your lordships towards a particular construction of some contractual provisions. We would encourage the board, insofar as we can, not to go down that slightly dangerous road, although it is necessary to understand the terms of clause 23 of the ICA, because that does give an opportunity for an approved RIO to have an impact on contractual relationships, subject to the serving of a notice. So there are lots of contractual points just left hanging by those few words. But, my Lord, I'm concerned particularly with 29.4 and whether it be the submission of the OUR that 29.4 gives it a power to intervene and assess an interconnection agreement which has been concluded and make a determination of the terms and conditions, including charges. And as I understood my learned friend's submission that for the OUR, that's exactly his case. That even though the parties have reached a concluded agreement, the office can come along at any time of its own initiative, assess that agreement, and impose on the contracting parties a new term and condition, including charges. My Lord, we say that that's a most remarkable state of affairs, and we repeat our submission made earlier that a logical reading of section 29 is that 29.4 is merely a step along the road in 29.3 terms. So if an ICA has been lodged, then the office may object in the prescribed manner, and if there was a prescribed manner, it would explain that in that process the office may assess the interconnection agreement and may make a determination of the terms and conditions. And that is a stark contrast with section 34, which is dealing with pre-contract disputes. So if there is a method, a clear method for pre-contract disputes, it would be truly astonishing if that's all swept aside, because later the office can come along and itself impose its own terms, even if there is no dispute between the parties at all. So, my Lord, I just wanted to explain again why we say that is of some significance. I also, at the same time, respectfully remind your lordships that the power that was in the end considered to be in play when the determinations were issued, 2.6, 2.8, was a concluded part of the decision of the Court of Appeal. And the Court of Appeal were faced with the argument by the OUR that whilst going through the RIO approval process, in other words, whilst exercising a Section 32 power, at the same time, unbeknownst to the parties, the OUR was also changing the terms and conditions of a finalised contract. And the Court of Appeal will have none of that. So there is before this board a section of the Court of Appeal's decision rejecting grounds 17 to 19, which deals with this very point, and it is not the subject of any cross appeal. Would it assist your lordships if I just showed you the section? It's bundle 5, tab 51. And so a little surprised to see 29.4 being relied on. Lord, it starts at page 2201 when dealing with grounds 17, 18 and 19. And my Lord, I won't take you to those grounds, but a cross-reference may assist. It's volume 4, tab 41, page 1869. The appellant, that's OUR in that appeal, therein contends that the learned trial judge failed to appreciate presumably in declining to consider and pronounce on the merits of...
It's all set out in the same judgment of 21666. All the grounds are set out verbatim.
They are, but they, just to, I was going to give you the original, but they are set out, as your lordship said. There's, I won't go through it, it's, there's reference then to estoppel, then there's reference to the interconnection agreement, and paragraph 23 is referred to. And over the page, this provision for amendment of the interconnection agreement was purely a matter between the contracting parties at their option, page 2202, middle of the page. There was no statutory provision that a subsequent RIO could retroactively modify their prior agreement. On the contrary, an interconnection agreement being entered is required to conform with the existing RIO. So that's their correct, proper reading of section 31. I am not of the view, however, in agreement with the Solicitor General, that an agreement between Digicel and Cable and Wireless could validate a determination by the OUR, which is not authorised by the Act, obviously. And then the learned President goes on to say the determinations 2.6 and 2.8 being part of the approval process of Rio 4 within the provisions of section 32 stand valid on their own. So that was the source of the power, and there's discussion in the judgment of 32 and 46. Lord, it's important to keep that in mind, because the submission is now repeated before this board that somehow miraculously the OUR could descend on contracting parties and change their contracts. Lord,
do you say that it didn't have any effect on existing contracts?
No, it didn't. Potentially, it had the effect that you saw in clause 23.
It had that effect?
Yes, the effect of approving the Rio had two potential effects. One is for everybody else, those who had not made contracts yet with Cable and Wireless for interconnection. And then it would be section 31.1 of the statute, so 31A, and if it wasn't 31A, then it would be by agreement under 31B. But where there was an existing agreement, then it would depend on what clauses were included in the agreement between the parties. And here you then have an argument as to whether or not there is an automatic impact on the existing ICA, which is apparently the submission being made by Cable and Wireless. Digicel would resist that and say that's not the case because notices have to be served, etc., etc. But the reality is that Cable and Wireless have kept back X millions, and the impact is certainly in the pocket of Digicel. So, Lord, in answer to your Lordship's question, the Rio is only an offer, therefore it goes forward to new contracts, but it can affect existing contracts if they're wrapped in. Well, I hope that answers that.
But they have, on your analysis, they have the OUR have two powers. They have the power under, well, subject to the as may be prescribed point, leaving that on one side. Do they have the power under section 32, subsection 3?
Yes. They have a power to address the Rio that is lodged
subsection
with them.
4, actually.
4, I was just pausing on 4, yes. They have a power to approve. They also...
Well, they have a duty to consider whether they're going to approve it.
Duty to consider and a power
So you have to be careful about saying that the contract is something very different from the offer, because in subsection 4 it says a reference interconnection, an RAO or any part thereof shall take effect upon approval by the office. Well, now offers don't take effect, so do they?
They do, my lord, in the scheme of this statute because of section 31A. If your lordship goes across the page, if you're in a double page, you'll see that each term and condition in relation to the provision of interconnection services provided
Where are you reading?
31 little a, my lord. It's where the word in effect is picked up by the statutory draftsman. Each term and condition in relation to the provision of interconnection services provided to each carrier shall be determined, which my submission is that means agreed or fixed.
Well, fixed.
Between the parties. A, in accordance with the relevant references, interconnection offer, or any part thereof which is in effect in relation to the provision of those services. So either the words is in effect only apply to any part thereof, but more likely it applies to the offer or any part thereof which is in effect, which takes you back to 32.4. It only is in effect when it's approved.
In effect, once it's open for acceptance.
Well, no, it's open,
Yeah.
no, my lord, when it's, with respect, it's in effect when it's approved, and then it's open for acceptance.
Yes. Well, the two happen simultaneously.
Yes,
Yes.
yes, but the words in effect
Yes.
are, one of the problems with this statute, you have to read it backwards. You start off with 32 and you end up eventually going to 29. It was written, I'll say no more. It was written slightly oddly.
You say that the effect of 31 is not something like that, 31A, 31 is sort of bit at the beginning and A, is not to make it a rolling thing. In other words, it doesn't roll on, it doesn't mean that the terms and conditions change every time that one of the, there's a new, somebody approves
No,
a new interconnection agreement.
no, 30,
Sorry.
I'm sorry, my lord. 31, as one flows through its language, is dealing with pre-contract. It's dealing with the negotiation towards and then fixing or determining contract terms. Either it's covered by 31A, if not, it's then agreement, and if it's not that, then you go off to pre-contract dispute. So it's all in that time period.
And approving an RIO is not on itself a capping operation. It's happenstance here that it had a capping effect.
No, more than that, my lord. It is what happened with this Rio, and why the minister was particularly unimpressed, to use a non-ministerial word, is what happened in 2.6 and 2.8, that there had been a cap before, a cap on the retail rate that could be the maximum that the retail rate could be charged by the mobile operator, because it's on the calling party pays system. The mobile operator who's going to receive, or where the call is terminated, could charge up to $12. And then the original RIO dealt with what could then be retained by Cable and Wireless, and there may have been a reference or not to bad debt, but the balance came to the mobile operator. What 2.6 did and 2.8 did was to cap or put a ceiling on that which could be paid back to the mobile operator. So for the first time, it produced its own fixed limit to the termination charges. Lord, it's explained quite clearly by the OUR's witness, Mr. Maurice Chavez, at paragraphs 13 and 14, in which it's volume 2, without taking you to it, just to remember the pages. Maurice Chavez, and this is why issue 3 is such a dead duck for Cable and Wireless. It's the last tab 12, my lord. OUR knew exactly what they were doing and did it. My lord, it's tab 12. It begins on page 910 as the beginning of Mr. Chavez's affidavit. He was the Director of Analysis at OUR. And at page 918, that's the record page, at paragraph 13, he deals at paragraph 12 with the paragraphs that are the subject of objection. Your Lordship, and you'll see it's 2.6 and 2.8. And it's 2.6, just if I read the first 3 lines, Your Lordships will get the what's going on. 2.6 is concerned with the maximum charge allowable for mobile termination. That is where a call is made from a fixed line to a mobile instrument. In the absence of regulation, the mobile carrier will be able to set artificially high tariffs, which will adversely affect customer, according to OUR. And then there's an explanation of the calling party regime. And then a third line down, without going through it all, unless therefore there is regulation of the charge, the mobile network would be allowed to make exorbitant charges to the fixed customer who has no choice when he wishes to telephone a particular mobile customer. So without going on, my lord, but I'm not dealing with the policy, but the clear intention was to regulate the charge flowing to the mobile network. And then across the page to 14, well, I'm not going through all of this for obvious reasons.
Paragraph 14.
14 on page 920, paragraph 14. Determination 2.8 is concerned with the rate to be paid by Cable and Wireless Jamaica to Digicel. And then the other, and any mobile network, and its own mobile network, for the termination of incoming international calls. Then he explains why, in the opinion of the OUR, regulation is desirable. And just below 10, the effect of regulation 2.8 is that in the event international settlement rates no longer cover the cost of mobile termination plus fixed retention costs, mobile termination charges on incoming international calls will be set at the lesser of the weighted average settlement and the weighted average cost of mobile termination. And right at the end, you will see the foot of that page, as Digicel is complaining, asking for the previous rates to remain. So it was the clear, not just the intention of the office, but this is how they did it. They intended to cap what the mobile operator could recover and set these rates. Well, does that answer, I hope, your Lordship's question? And that's Mr. Charvis's affidavit. Lord, so what I was saying earlier is I wanted to respectfully just spend 1 or 2 moments on that statutory structure in case your Lordships were, again, I use my words.
Could you just say again, because I'm not being a rather slow member of the class, I'm not sure that I fully followed it. What is meant then by take effect in subsection 4 of section 32?
My Lord, if you go back to 27,
Yeah.
your Lordship will see that this is the part of the Act dealing with interconnection. And the definition of the reference interconnection offer that Mr. Garcia took you to in 27 to describe this as an offer document on which the public voice carrier will permit interconnection. So what you're looking for is the terms upon which, at that stage, Cable and Wireless Fixed would allow Digicel, Centennial and others to connect. And leave 28, which is dealing with dominant, and 29, each carrier shall permit connection. Then you get to 29.3, copies of all interconnection. Oh, I'm sorry, my Lord, I've missed it up. 32. This is why it's written in such an odd order. If you go to 32, every dominant carrier shall, and any other carrier may, lodge with the office a proposed reference interconnection offer, upon which other carriers may interconnect. And then you go to the top of the next page, 31.2, every dominant public, it might be the wrong way around, my Lord. In 2, each dominant public voice carrier shall lodge, but then it's the existing telecommunications carrier, which we know is Cable and Wireless by statute.
I mean, here there was no dominant public voice carrier.
The only one that mattered at that time was Cable and Wireless.
Right, and they're the existing telecommunications.
Exactly, yes. And they were declared dominant in the fixed market. Yeah. I'm not sure they were at that particular time, but they were. And so they are, what they're doing is they are lodging a proposed RIO.
Yeah.
That then goes to the OUR, which shall approve it, and when it approves it, it takes effect. The problem with 32.4 is there's reference to the prescribed manner again.
Leaving out the prescribed manner, then what is the answer to my question, what's meant by takes effect?
Well, my Lord, it takes effect because from that moment it becomes a Section 27 reference interconnection offer that can be the basis upon which interconnection can be permitted. Because until it takes effect, it is only a proposed interconnection offer. But that only applies to either a dominant carrier or the existing telecommunications carrier, Cable and Wireless Jamaica, or any other carrier who chooses to put their proposed IC Rio reference interconnection offer to the Office for approval. So that it then takes you back to 31A, because you have to have at least an option as to whether or not there are provisions in the approved Rio, in other words, the Rio which is in effect, because unless it's in effect, you don't have to incorporate it. You go to 31B, which is agreement.
Here at the time of the agreement, was it in?
At the time of the agreement, Lord, there was a Rio, and that was Rio 3, which had started its iteration as a Rio in 2000 and had reached its third version by either just before, days before, the signing of the agreement in April 2001.
So this was an A, 31A?
This would have been a 31A compliant agreement. And so far, and indeed, I think it's either Mr. Hay or Mr. Chavez said this agreement didn't need separate non-objection under section 29.3 because it was compliant with almost all of the provisions of the approved Rio. So they couldn't really object because they approved the Rio.
Now, can you just help me on this? As far as 2.6 is concerned, one understands the justification put forward to this. It is to protect the fixed user, as it were, against a mobile, grasping mobile operator.
That's the OUR's.
Yeah, but is there also any motive so far as Cable and Wireless were concerned for having 2.6? Or was it really introduced by OUR in the public interest?
Oh, no, Cable and Wireless would be thrilled with 2.6 because what was happening in February 2001, the OUR had set a cap for the retail charge that could be made by Cable and Wireless to its fixed customers, but that what was going to be in that charge was determined by the mobile carrier who was to receive the call. So just using the same players we have here, Digicel would say to Cable and Wireless, you will charge to your retail customer 8, not 12, but 8, leaving that headroom which Digicel could then use to its market advantage, or other telecommunications mobile network operators could say you charge 10 or you charge 7. So there was flexibility available to the mobile network operator, but these were Cable and Wireless's customers. So the complaint by Cable and Wireless is that their customers were being charged more than they, Cable and Wireless, wanted to charge them because of the calling party pays system, but they didn't want a flow of funds to come from their customers through Cable and Wireless into the coffers of Digicel. Digicel could then use that money to advertise, to promote their products, and to roll out their service.
So their interest in this was not that it was going to reduce their take. Their take was a neutral factor in the middle,
Yes.
but it was going to reduce the profits that their competitors were making.
Exactly.
Now that's not true, is it, of the international picture? Because as I understand the international picture, they were actually going to profit
Yes.
by the cap.
Well, it's both. It's,
Yes.
There would be a movement of money. Instead of it flowing through to Digicel, it would stick with the Cable and Wireless.
But what was coming in
Yes.
would be just as much. So it wasn't actually doing the customer any good at all.
Yes, this is in, I think it's Mr. Hall's witness statement or affidavit in the bundles. He explains not only do they Digicel lose X million or 13%, whatever it is, but the effect of that is that they lose the money and give it to their main competitor. Staying with 2.6 for a moment. Before 2.6, I've used 8 or 10 as the Digicel required charge. The retention was already fixed for cable and wireless. So they would, I think it was $1.8, whatever it was. Then they could keep back something like 8% for bad debt relief, and then the balance flowed. 2.6 fixes that amount.
They're cut.
Yes, to $6.83, whatever the amount was for peak rate.
Yes.
So that's why it sets a cap, and that's why Digicel are unhappy, and that's why cable and wireless are here, because they have potentially benefited from it. Lord, I'm happy to go on with that.
Yes.
I'd just like to ask one last question relating to the determination in November 2001,
Yes, ma'am.
which is said to be an interim determination, which is set out at page 773 of the record, where they provide some interim figures, and then they say these modifications are effective as of November the 22nd and remain ineffective subject to the final determination. Now, what effect would that have on your client?
That had raised it by 8%.
Lord, it had an effect, and it wasn't objected to at the time, as I recall the evidence.
But would it alter the figures in Rio 3?
No, my lord. Yes, Rio 3 would certainly impact. Rio 4 would have an impact.
Precisely. So would this determination in relation to Rio 3, at any rate, subject to its terms, have the effect of amending the figures in Rio 3?
Yes, my lord.
2.3.
Yes, I'm sure. In fact, whether it amended the figures or covered a new area, I'm not quite sure. I think it amended the figures.
I think it did, yes, because this is about the figures. Yes,
Lord, before I leave the statute, could I just mention section 33, because a point was made by both respondents that they could have made somebody dominant the day after the ministerial direction, and they were being prevented from deciding whether somebody was dominant. Well, that's, greatest respect, a thoroughly bad point, because if they did decide that one of the players was a dominant carrier, either in the mobile market or in fixed.
That wasn't the submission.
Wasn't it?
No. I wasn't deprived of making someone.
Well, nobody made the submission, so I won't respond to it. But if it was made by anybody, it would be a terrible point, because the minister's direction is within his power to make another direction if the circumstances have changed. Well, that's all I wanted to say about the statutory framework. And I wasn't going to spend time on clauses 10 and 23 of the contract, because that would take us into submissions on what is meant by clause 10, whether it bites at all. We say it's got nothing to do with amendments to the Rio. Clause 23 could have, but that has a mechanism which is the subject of potential dispute between the parties, and I say no more about it. Lord, on issue 1, as I said earlier, my Lord, there was when opening 2 days ago, I was asked whether there were cases which dealt with this language, and I threw out British Coal Corporation, mainly because it's politically famous, if not itself a most famous decision. But subject to judicial interest, could I show it to your lordships, and then very quickly, it's a decision of the Divisional Court in 1992, and it's only reported, unfortunately, in the Industrial Relations Law Reports of 1993. But if I show you the passage,
We haven't got it.
it should be available probably on...
Well, while it's just being passed, could I just ask you this, going back to the facts?
Yes, ma'am.
To get some feel for the picture. What was it, or what one might one be justified in concluding, was it, that caused the minister to act? Was it that he was being pestered by these complaints about these negotiations, which woke him up to their effect. And he really said, well, a plague on all of this. This is going to have a very bad effect on new entrants, these kind of restrictions.
Lord, I'm deliberately, and didn't do so on Tuesday, speculate beyond the Minister's evidence.
Yes.
And that's why I was keen that the board should see what he said in affidavit form, but also what he said in correspondence. And he's rejecting expressly that there was some kind of agreement that he was taking part in, or was he behaving in any way improper. But clearly what he was doing was hearing complaints. He was hearing grumblings. Whether he was hearing the same grumblings from AAT, whatever the initials were, that the OUR were hearing, I suspect they were different, which is not unknown for somebody who wants to come to the market to talk to the minister differently from the regulator, who may be there to regulate. But he had input. He considered that this was a delicate time when market forces should prevail, and he's explained in uncontradicted paragraphs his reason. But I can't go further than that.
We still haven't got this authority.
It's this one, tab 3.
Well, we produced enthusiastically a supplemental bundle in case we had to deal with the status of the rules and regulations. So there is a second supplemental bundle of authorities, and it's tab 3. Your Lordships are spared, unfortunately, some of the interesting developments on the difference between mandatory and directory. There's a bundle that was handed up this morning, my Lord. Tab 3 is the only one I want to take you to.
What's on the outside?
It says second supplemental bundle of authorities. The first is Charles.
Yes, thank you.
And the interesting case of Clark is for somebody to read another time. But tab 3 should be Crown against British Coal Corporation, Secretary of State for Trade and Industry ex parte Vardy. The reason that it was politically important is this was the closing of the pits in the early 1990s, which led to industrial action and marches down Fleet Street. But this was a judgment of Lord Justice Glidewell as the Divisional Court sitting with Mr. Justice Hidden. And if your Lordship turn to the third page of the photocopy, paragraph 1, and the only point to note is just above paragraph 1 is the list of the appearances, and for the Secretary of State for Trade and Industry is Stephen Richards and Philip Havers. It's not to identify them, but just to show who Mr. Richards then was representing, because he's referred to in the text. Lord Justice Glidewell explains what is happening historically, and taking this very briefly indeed, there was complaint about statements made by the Coal Board, British Coal, who had announced, as you'll see in the first 3 lines in paragraph 1, that it had concluded regretfully that a total of 31 collieries must be closed, of which 4 will be placed on a care and maintenance basis. On the same day, at the foot of that paragraph, the Secretary of State, now the President of the Board of Trade, is reported as saying, this is the toughest decision I've ever had to make, etc. The details of the statement I'll come to in a second. At paragraphs 10, 11 and 12 are the complaints. And one of the particular complaints is a declaration in 12 that the Secretary of State may not give directions to British Coal under Section 3.1 of the Coal Industry Nationalisation Act 1946 as to the closure of collieries unless he has allowed the MCRP to be followed, which is a negotiation process, and to set up an independent inquiry to consider the merits of generating electricity from coal and other fuels. Over the page at 22 should be Section 3.1 of the 1946 Act. The Minister may, after consultation with the Board, give to the Board directions of a general character as to the exercise and performance by the Board of their functions in relation to matters appearing to the Minister to affect the national interest, and the Board shall give effect to any such directions, so not dissimilar. Well, Lord, if your Lordships turn to paragraph 71, is the complained of direction. there are two, my lord, one at 71 and one at 76. And I won't read them to your lordship because you'll see that they are lengthy statements. One is a press conference on the 13th of October, and the other is a statement to the House. And your lordship will see that what he is saying is that he has allowed the board to close 10, but that they have to go out for consultation on the balance. And not only does he approve the 10, he points the finger and names the particular collieries that are about to close. And you'll see that in the text, and indeed it's repeated earlier on in the judgment. So what one eventually then came to was the reasoning and the challenge to the decision of the President, and it's at paragraph 88, my lord. And in order to consider the nature of the decisions made by the President, it is necessary first to determine what powers he was exercising. Then it's read out. And I should, before I read on, I should mention that Mr. Richards, for the Minister, was saying, I wasn't exercising that power at all. How can you accuse me of getting it wrong when it wasn't what I was doing? Mr. Richards submits that wide-ranging and important though the decisions announced by the President on the 13th and 19th of October were, they were not directions of a general character. I agree with this submission. It follows that the President was not exercising a power under Section 3.1. Mr. Richards argues for the President that the President's decisions were made not under any statutory power at all, but under some general responsibility, and to cut a long story short, that was rejected, but the President was acting under a different statutory power, and that's to deal with the organisation of the Coal Board, and that's dealt with over the next few pages. So what we have, my Lord, is a brief comment by Lord Justice Glidewell that he agreed with the submission that the lengthy statements were not directions of a general character by a minister who was not claiming to make any direction at all under the section. But, Lord, that's the best we've got. And I'm sorry it isn't wholly helpful. The difference, my Lord, is that here we have a minister who does purport to be relying on Section 6, has explained why, and the direction is not specific in the sense that it doesn't refer to a specific operator or compel a specific rate. It is, we submit, a general statement and heavily, very heavily policy-laden. Lord, one final submission on issue 1, and that's I haven't responded to my learned friend, I think in the end it was Miss Minot Phillips, who sought to convince your lordships that there was a freestanding power to regulate under Section 4 of the OUR Act, or we merely repeat our submissions that that can't be right because it flows through to the Telecommunications Act. Well, could we undertake to file with the board as soon as we have it to hand the amending statute, which is 14 of 2000? We still don't have it, my Lord. Lord, that's all I wanted to say on issue 1. On issue 2, there's really, just checking there's nothing else I wanted to say on that, my Lord. On issue 2, we can take this very briefly indeed. My Lord, what we are seeking to argue in issue 2 is that there is a fairly important principle of law that a decision not invalid on its face is valid until set aside by a court of competent jurisdiction, best encapsulated by Lord Denning speaking in a different case. This is now in the Hoffman-La Roche case, and I just quote from page 322B to C, unless and until the courts declare it to be so, they must obey it. And that was a ministerial command. So unless and until the courts declare it to be so, they must obey it. They must obey first and argue afterwards. Now that's the principle that we seek to...
where in Hoffman-La Roche is that?
Page 322B to C. And, my Lord, in the textbooks, my Lord, it's perhaps all best summarised in the 2 extracts from De Smith, 6th edition, which is in volume 5, and at tab 62, and in Wade, volume 5, tab 66, where the case law is summarised. I think that extract appears. Lord, we were trying to find the recent decision which your Lordship, Lord Brown, mentioned. We thought it might be Ass, An and What, but it didn't look right in the end. But it could be McLaughlin. If it is, that's already in the bundles at volume 3, tab 30, at paragraph 14 to 15. But Lord, we couldn't, I'm afraid, find the other case that says either a different or the same statement as we find in Hoffman
The
and Roche.
old case is something I was on called Percy, and I'm not sure, were you in it?
There was a case called Percy and Hall.
That's right. Was
Lord,
that anything to do with it? Or am I aberrating?
No, not at all, Lord. This was the one that came at the same time as Bug that led to Boddington.
Yes.
And it's whether or not two peace protesters could rely on a defective bylaw in suing the arresting policeman for false imprisonment. And that led to, I'm not sure I should say this, but I suppose I can, that led to exchanges between me and now a co-author of Wade, called Mr. Forsyth, which led to the second actor theory that has bedeviled us ever since. So in Percy and Hall, the second actor, the first actor was the Secretary of State who made the defective bylaws. Miss Percy and Miss Greaves, who were trying to get onto a military of defence establishment, were arrested. They wanted damages for false imprisonment, and it may have been your Lordship, but certainly the Court of Appeal said, get out of here, and it took them many pages to say that, because the unsuspecting officer was a second actor and could rely on the validity of the bylaw in order to arrest.
That's with Evans number 2 or something?
Then it became Evans number 2, and eventually we get to Boddington. My Lord, yes, I remember Percy and Hall exceptionally well.
How is it really relevant here?
Paragraph
I mean, how does it arise in our case?
Paragraph 48 of our printed case, my Lord,
yes.
is what we're saying is this is not a Boddington-type case.
I understand that, but what is the knock-on effect
Well, it's one sentence.
on this actual case?
Until this...
But why does any of that matter?
Because it was contrary to the direction to issue that determination, and your committee is invited so to declare, and it could not have issued 2.6 and 2.8 until a court of competent jurisdiction had struck it down, and that was December 07. What they can't do is act in defiance of the ministerial direction, issue their determination, wait to be sued, crossing their regulatory fingers, and then say when it's quashed, it goes all the way back, and therefore what they did, although in defiance, was lawful. We say that's the wrong way to approach what I've extracted from Hoffman and Roche. The public regulator, unlike the private citizen, faced with an order from a minister, unless it's bad on its face, must comply with it. And if it wants not to comply with it, then it must take it for a declaratory relief. Or somebody else must. But what it can't do is issue 2.6 and 2.8 in defiance. It's paragraph 48. It's our fallback position. So,
on that view, both your direction and the OUR's determinations would all fall.
Yes. Yes. Or they could be resurrected as from the date when the Court of Appeal declared this to be an ineffective and unlawful direction. What they couldn't do is then say, ha-ha, we were right all along, look at the Council's opinion, and then say it was effective from May 2002. Well, that's the argument in a sentence. Whether your Lordships like it or not is, unfortunately for your Lordships. Well, that's issue 2. Except I've touched on Boddington. We have not found any case anywhere where a Boddington argument has been used by a statutory regulator to say that they could treat themselves like a private citizen and wait to be arrested or wait to be charged or wait to be sued. So we say that that's a misunderstanding. Issue 3, my Lord, I've probably dealt with issue 3 by now, that your Lordships have seen as I was dealing with the meaning of 2.6 and 2.8, that they have a clear impact on a mobile network, and any submission to the contrary is misconceived. And you have, my lord, paragraphs 13 and 14 of Maurice Jarvis, which regrettably means I can't deal with issue 5, unfortunately. But could I, as I commanded to do by your practice directions, mention the question of cost before I sit down? My lord, there are potential difficulties in costs, and could we invite your lordships to allow written submissions at the delivery of your advice to Her Majesty? Lord, unless I can assist you further, those are our submissions.
Thank you very much. The board is grateful to Council for their submissions and will take time to consider what advice they will humbly tender to Her Majesty.
Stupid arrangement, this is. It really is a bloody stupid
I must tell you what my grade is. Yeah, I'll tell you what my grade is.